Well, a very good morning, everyone, and thank you for attending our webinar this morning, which is a contract law update. We give these sorts of updates fairly regularly, as we think it's always helpful to know what new and interesting, well, hopefully interesting, we think they're interesting, cases have been coming through. Just to introduce myself, my name's Jo Rhodes. I am a senior associate in our commercial litigation team, and I'm also one of the co-chairs of ThinkHouse Foundations. Just to say a little bit about that, ThinkHouse Foundations is the partner programme of our main ThinkHouse series. While the main ThinkHouse series is aimed at senior in-house lawyers all the way up to kind of GC level really, ThinkHouse Foundations is aimed at the more junior end, from trainee solicitors all the way up to kind of 5 or 6 PQE. And what we do in Foundations is we try to focus on giving practical assistance with the things that we think might be coming across your desk from day to day. I'm informed that we started ThinkHouse Foundations with 1 talk and about 10 people in attendance. So looking at our participants today, I think we've come a little way since then. I have the pleasure of chairing this webinar today, which is the third and final in a series of 3 ThinkHouse Foundations webinars for the spring and summer season. On the 11th of May, Sam Cooper from our planning and environment team kicked off the spring summer programme on the topic of a new era for environmental law. That was swiftly followed by a panel discussion with the possibly slightly thorny title of Brexit, What You Need to Know, in which I was joined by several lawyers from across some of the firm's key specialities, talking about what they've been seeing most of in their practice area since Brexit, as well as things to look out for and what they think might be coming down the track, to the extent anyone's able to predict that. If you weren't able to make either of those, I am biased, but I do of course highly recommend them. We record all of these sessions, and the links to all 3 for this season will be circulated to you all at the end of this talk, so please don't worry if you couldn't make either of them. I think the final thing to say before I introduce our speaker for today is that there will be a link circulated after the webinar to complete a very short feedback questionnaire. And I do promise that it's short. If you do have a moment, we'd really appreciate any thoughts you have on today's session and anything you'd like us to cover in the future. Your feedback is really useful in helping us to shape future programmes, so please do take a moment to complete it if you can. So, moving on to today's talk then. I'm very pleased to be joined today by Sarah Townsend, who is a fellow senior associate in our commercial litigation team and who joined the firm last year. In the spirit of what we try to do with ThinkHouse Foundations, Sarah's going to give a practical overview of some of the cases which have been coming up over the last few months or so, and which we think relate to things that are likely to be appearing on your desk from day to day. We have, just the last bit of housekeeping, we have activated the Q&A function on Zoom, so please feel free to ask your questions there. And just to say that only we will be able to see them and they're not visible to your fellow attendees. We'll try to answer as many as we can in the time allowed, but if we don't get to everyone's, we'll follow up after the session. And equally, if there are any specific queries you'd like advice on, we'll be very happy to follow up afterwards. I think that's enough out of me. So without further ado, I'll hand over to Sarah.
Thanks very much, Jo. As Jo said, I'm Sarah. I'm a senior associate in the commercial litigation team. I work with Jo handling all manner of disputes, recently from VAT fraud claims to breach of contract claims, particularly arising out of COVID, which is something that we're going to look at later this morning. I should also mention too that I worked in-house as an NQ litigation lawyer at a finance company, and so I very much appreciate the demands placed on in-house counsel, especially the sometimes seemingly impossible requirement to be an expert on all matters and provide advice often at very short notice, from what I remember, across a diverse diverse range of subjects. So as Jo said, the aim today is not a law lecture or to dig out your potentially dusty law books. It's looking at some practical cases which have come through in the last year and a half, which we think may have some interest and hopefully some practical application on your day-to-day jobs. So I hope you all have your morning coffees on this beautiful morning, perfect morning for a contract law update. So turning to our agenda today, we're going to start by looking at everyone's favourite law school topic, frustration, and in particular recent decisions of the court, considering both COVID and non-COVID cases, which we hope might be of some relevance and some interest. We're going to then move on to look at whether COVID-19 can be used as a defence to money claims particularly, which again we hope is a fairly topical discussion. Then the theme for the rest of the topics we're going to look at is really looking at some common phrases which you no doubt have all come across in your day-to-day jobs, and that you've also read in probably numerous contracts, but do we actually know what they mean? So the first one is, what does subject to contract mean? And in particular, there's been a really interesting Court of Appeal decision which discusses and examines exactly that. What does subject to contract mean in discussions, and what are the consequences of it? We're then going to move on to, again, another quite well recognised phrase, which I'm sure you've all come across, and is giving consent under the contract. And this is particularly whether a party can impose conditions upon giving consent under a contract. And then we're going to end today's session by looking at another really, really well-known phrase, the duty of good faith and the extent to which a party has to act in good faith under a commercial contract. So again, we're going to consider briefly what the courts have said and the background of the cases, but again, just kind of looking at the practical implications of that. And if you come across it in your day-to-day jobs, hopefully it would have some practical application for you. Great, so turning to our first topic of the morning, which is frustration. And this is, I hope, hopefully an interesting case. It's Dyer and Bushlow Street Surgery. And to start off with the very basics, frustration, and it's something that we all remember learning about at law school, probably has a relatively limited application, maybe in your day-to-day jobs, but something that always pops up now and again. Then not to drag you to your law book or to give you a law lecture, but what are the essential elements of frustration? And here it really goes to the impossibility of performing a contract. It's something which makes a contract physically, legally, or commercially impossible to fulfill. And another key phrase which keeps popping up in a lot of judgments is this fundamental, radically different obligation that the parties intended from the outset of the contract. And so it's looking at events which basically really render the performance of a contract very, very different from what the parties first intended. So looking at this recent case of Dyer, just to give you a bit of brief background about what the case was about, Mr. Dyer and his partner ran a medical practice along with two other GP partnerships. The parties all entered into a number of contracts for a lease of the premises and also facilities management agreements. Unfortunately, in 2015, the Care Quality Commission tried to cancel Mr. Dyer's registration as a doctor, and his patients were transferred to the other partnerships in the building. Now, luckily for Mr. Dyer, he appealed and his registration was reinstated a year later. However, during this time, Mr. Dyer and his partner did not meet any of the obligations under the contract, including the lease. And to make matters worse, the other partnerships sued for breach of contract and were awarded £27,000. Now, during the course of these disputes, Mr. Dyer had relied on frustration arguments. And he argued that during the period he wasn't practicing, he was still obligated to pay the running costs of the GP premises, and that this had turned into an obligation to make payments for nothing in return. And that was radically or fundamentally a different obligation than that agreed at the outset. Going back to our definition of what frustration is. Now, the court, unfortunately, Mr. Dyer disagreed with his frustration arguments. And it noted that the lease had imposed an undertaking on the tenants to use their best endeavours to remain a GP, and that the other documents and contracts required the parties to covenant with one another to use all reasonable endeavours to remain a qualifying practice. So when considered in the round, the contracts made sufficient provision for the possible cancellation of a party's GP registration, and therefore a frustration of the contracts had not occurred. Now, it's also relevant in here, one of the kind of interesting points is that upon the cancellation of their registration, Mr. Dyer, by his actions, showed that he did not consider the contracts to be frustrated. His decision to appeal the cancellation of his license, which is ultimately successful, showed that he wanted to continue the contracts rather than treat them as frustrated and simply walk away. And the court placed weight on that. So the practical points to take home if you ever come across this type of scenario or frustration argument in your practice or in your work is that this judgment shows that just because a situation arises which is outside the party's control and has very harsh consequences, discharge of the contract by frustration will not always be available. Quite a difficult argument to run. You have to consider all of the circumstances and contracts together. So here, particularly, the contracts do not refer to the possibility that the GP's license may be terminated, which you think would be a good point in support of a frustration argument. However, that the court concluded that the general possibility of cancellation had been envisaged. So practically, it would be prudent to take an expansive view of contractual provisions if you were ever seeking to rely on a frustration argument. So just because something hasn't been specifically mentioned in the contract, you have to see whether it's been envisaged by the contract and take that more wide view of the terms. It's also important that you consider your actions immediately following a potentially frustrating event. This is going to be crucial when the court analyses the impact of the evidence. So if you or the other party do something which reaffirms the contract or shows that you want it to continue, the court will place weight on that and ultimately decide that you didn't intend or you didn't consider the contracts to be frustrated. So moving on, we now look at frustration in the context of COVID, which is something you have no doubt read legal updates on and something which is particularly relevant at the present time. Now, this is a really interesting area and one which will likely undergo some significant changes as parties increasingly seek to rely on the doctrine of frustration in respect of trying to escape various commercial contracts. In particular, from my own experience, one of the cases I'm currently working on relates to cancellation of various international cruises as a result of COVID-19. And one of the interesting things, or slightly off-putting things, if you're caught up in a dispute of this nature, is that there is a risk that the courts may change their approach in dealing with frustration cases in view of the sheer number of cases which will potentially most likely hit the court in the coming months and years. So it's very much a watch this space as to how the courts go about approaching these cases. But one of the interesting or recent cases which we wanted to flag was Salem and LATAM Airlines. And this is probably your typical frustration case and one which you would most likely envisage having application to frustration. It's an airline case. So Salem was an airline operator in Oman, which leased a number of aircraft from a company called LATAM. Under the lease, Salem had to pay rent in monthly installments for 6 years. The lease said that this obligation was absolute and unconditional, and that's a really key phrase and a key contractual provision. The lease further required Salem to provide standby letters of credit as an alternative for paying 3 months' rent as a deposit. Now, obviously, following the outbreak of coronavirus, the Public Authority for Civil Aviation issued a series of regulations which prohibited all flights to or from Oman airports. The leases were terminated by LATAM in 2020, but at that point, Salem had paid no rent since March 2020, so there was a significant portion of rent outstanding. Now, interestingly, Salem took the initiative here and commenced proceedings in London, seeking to restrain LATAM from demanding payment. Salem argued that the aircraft leases had been frustrated by both the coronavirus pandemic and by the regulations which prevented any flights from taking place. And accordingly, it argued that no rent was payable. So quite a bold argument there, but an understandable one to pursue in the circumstances. And you may think, as I said, this is your typical kind of coronavirus frustration case, and the court would have sympathy with it. But unfortunately not. The court did not agree with the arguments on frustration. The terms of the lease it held were clear. The obligation to pay rents was absolute and unconditional, irrespective of any contingency whatsoever. The regulations may have prevented Salem from using and utilising the aircraft in its business, but it did not prevent either party from performing its obligations under the contract. So the take-home point here, if there is one, is that you may think that there couldn't be a clearer example of a frustrating event than COVID-19 and its impact on the airline and travel industry. However, this case is a really good warning that you must read the contract. If obligations are expressed as being absolute and unconditional, you should tread carefully in seeking to rely on frustration arguments. And obviously, that's not always going to be the case. You can well imagine some commercial contracts providing for frustration as a result of pandemics, which is a contract I'm dealing with at the moment, and therefore the courts may have it completely differently. But just because of something as significant as COVID-19 and its obvious impact on something like the airline industry, does not mean that the court is going to take a sympathetic attitude. It's going to want to hold parties to their contractual obligations and not seek to release them if the contract doesn't provide for it. So it's something, read your contracts carefully, I think there is the take-home point. So we're now going to move on to our next topic. And again, it's looking at COVID-19, but we're leaving behind our contract, our adoption of frustration, and we're looking at something slightly different. So whether COVID-19 can be used as a defence to a money claim. Now, this is one which may interest property lawyers, but will hopefully be of general relevance and interest to other lawyers as well. We're looking at a particular case of Commerce. I'm not going to try and pronounce the full name of the company, and PFS. This is quite interesting in that it's the first judgment to be handed down relating to a claim for arrears of rent and service charge for retail premises, where the tenant relied upon the closure of retail units imposed during lockdown as a result of COVID-19. So to give you a little bit of background about what happened here, the tenant had a 10-year lease of a unit at Westfield London Shopping Centre. As a result of coronavirus, as a non-essential retailer, it had been required to close. Even during the periods it had been allowed to open, there were so few customers in Westfield Shopping Centre that they didn't make much money. And as you can imagine, the tenant suffered financial hardship, which it claimed prevented it from paying the rent and service charges due under the lease. Unsurprisingly, again, the landlord sued for arrears of rent and service charge, and the tenant sought to defend the claim, quite inventively in this case, and quite creatively. One of the arguments it raised was that the claim was premature as a result of guidance given by the government for commercial property relationships during the COVID-19 pandemic. And for those of you who haven't come across it, that particular guidance, I certainly hadn't before this case, the guidance encouraged landlords and tenants to work together collaboratively with the aim of lessening the impact of the pandemic. And it was very much guidance for parties involved. It wasn't law, it wasn't statute. At the hearing, the tenant also sought to argue that it was an implied term of the lease that the landlord should seek to claim on its insurance before seeking payment of rent from the tenant. So it was really creative and tried to chuck every argument at the court to escape its rent and its service charge obligations. Unfortunately, again, for the tenant, each of the defences was rejected by the court, which awarded summary judgment for the landlord for arrears of rent and service charge. And if we look particularly at what the court said in relation to these COVID-19 arguments, so going back firstly dealing with the argument relating to the code of practice, it expressly stated that it was not intended to alter contractual relationships between the parties. It was merely guidance as to practice. And the key point here is that a landlord still has a right to bring a claim against a tenant for money due, for example, for outstanding rent arrears, even in the COVID-19 pandemic. And I think it's quite an interesting point because I certainly have seen lots of headlines about how tenants are pulling their hair out because landlords are pulling their hair out because tenants can stay in rental properties during the COVID-19 pandemic and of the financial burden placed on landlords. But here's a really useful bit of guidance to say, no, that isn't the case at all. The landlord still has the ability to pursue judgment against tenants for outstanding rent, even during the very unusual time which we're in, which is helpful if you're a landlord, not so helpful if you're a tenant. Also in relation to insurance, again, the court rejected the argument that the landlord should go to its insurer for payment of rent before seeking payment from the tenant. The landlord was not under any obligation to insure against risks other than those specified in the lease. There was no implied term that the rent would be suspended when the premises were forced to cease trading, or that the definition of damage has been extended to damage caused by the pandemic. So again, if you ever come across an argument, or maybe you're wanting to pursue it, that the landlord should go to his insurer first, it's not going to fly if it comes before the court, most likely in any event. So turning really to what are the take-home points from this? Well, the judgment showed that it's incredibly, extremely difficult to imply a term into a carefully drafted commercial lease that rent will be suspended during a period where the premises are forced to cease trading and closed due to government intervention. And while it's undoubtedly the case that retail or other commercial tenants have suffered significantly as a result of the pandemic, the court can do little to alter contractual relationships between the parties. And so I think it's following on from previous cases we've looked at this morning, it's a really good example that notwithstanding the devastating impact and devastating commercial impact that COVID-19 is having on parties, including tenants, including airlines, the court are not going to have a sympathetic approach if the parties have contracted with one another to fulfill certain obligations, such as paying rent and such as paying service charges. They're going to want to hold them to their contractual obligations, irrespective of this very unusual circumstance. So it's something to keep in mind. Again, if you're wanting to rely on COVID-19 or you're faced with a COVID-19 argument to effect. So moving on, away from COVID-19, which you may or may not be relieved to hear, to our next subject. And again, as I mentioned at the beginning, the theme of the next cases is very much going to be looking at commonly used terms, which I'm sure you're all incredibly familiar with, but do we know what they really mean? And in particular, there's been a spate of recent cases which have considered these terms. And so it may reaffirm your understanding or it may challenge it. We'll have to see. So the first phrase we wanted to look at is subject to contract. And again, it's something which I've used on a lot of discussions with other sides, a lot of settlement discussions, especially when you're trying to negotiate, in my case, normally settlement agreements, but no doubt with commercial and property lawyers out there where you're trying to negotiate commercial contracts, it is no doubt something, a phrase which is littered in your email correspondence with the other parties. But just to reaffirm everyone's understanding as to the implications of using that phrase. And so the case that we want to particularly consider is Joanne Properties and Moneything Capital. So here, just to give you a flavour of the background to the case, Joanne Properties owned a building in Wandsworth. It borrowed money from Moneything Capital secured by legal charge over the property. Now, Joanne fell into arrears and Moneything appointed LPA receivers. Joanne challenged the appointment and issued a claim and an injunction to prevent the LPA receivers from taking any action. The parties subsequently entered into discussions to see if the dispute could be settled, which is no doubt a very sensible solution, something which we always encourage clients to do if particular circumstances lend themselves to it. Now, they did this successfully and agreed that the property should be sold and the proceeds distributed between them. There was a formal written compromise agreement which stated that the sum of £140,000 be ring-fenced, and this sum represented any sums which may be payable subject to the terms on which the claim was resolved between them. Now, the claim actually went to the Court of Appeal here, and the question before the Court of Appeal was whether the parties had reached a further binding agreement contained in communications between their solicitors about how that sum of £140,000 was to be shared between them. Now, the parties had labelled their various communications as subject to contract. Various offers had been made, which had been headed without prejudice and subject to contract, something which I'm sure is used by many of you. Further discussions resulted in an agreement to pay anything, and these had taken place also on a subject to contract basis. However, the parties hadn't agreed all the terms. They hadn't agreed particularly, relevant here, the mechanics of payment of that £140,000 sum. Now, later that month, Joanne changed solicitors before any consent order had been agreed. It then sought to backtrack and argue that there was no binding agreement because the negotiations had been, surprisingly, subject to contract. Moneything disagreed and made an application for an order on the basis that there had been a concluded agreement between the parties. Now, the matter went before the Court of Appeal, which held that there had not been a concluded agreement on the basis that the discussions had taken place on a subject to contract basis. So I'm sure you're all breathing a sigh of relief about. It also took into account the parties contemplated drawing up a consent order to reflect any agreed terms. Now, the consent order here would have been the equivalent to a contract, and it is clear that the parties had failed to draw up such a document. The Court of Appeal helpfully reminded us what subject to contract means. And here, it was that neither party intends to be bound either in law or in equity, unless and until a formal contract is made, and that each party reserves the right to withdraw until such time as a binding contract is made. It also reminded us that once negotiations are stated as being subject to contract, that condition is carried all the way through negotiations. So practically, if you did want to switch between discussions subject to contract and terms which were you consider to be a formal binding agreement between the parties, you would have to state so in communications. So I'm sure many of you, as I was breathing a sigh of relief when I found the Court of Appeal's judgment. And the take-home point really here is the judgment provides a welcome reassurance that entering into negotiations subject to contract will not result in any unwanted or unforeseen contractually binding agreements, provided that the parties make it clear that their discussions are and continue to be subject to contract, for example, by using that term in email subject headings. And as I briefly mentioned earlier, if you did want to change, you would be wise to explicitly state that in your communications with the other side. And to continue, just make sure that that phrase is included in your email correspondence for clarity, and so that the other side can't take arguments such as Moneything did here, that there had been a binding agreement at some point. So it's a welcome relief, sure, that you can go on using the phrase subject to contract, as you probably do already, and that there won't be any negative implications for that, indeed only positive ones. So moving on to another phrase we thought would be useful to explore, and it's giving consent under a contractual agreement. The case that I particularly wanted to look at was Apache and Ineos, which I hope I'm pronouncing correctly. And just to give you an overview, this concerned whether a party can legitimately withhold consent under a contract or make consent conditional upon certain events taking place. Now, all the property lawyers out there will be extremely familiar with the requirement of parties to give consent under leases. Kind of your typical example, it's something which I remember from law school days and my property seminars. But this case is particularly interesting in that it relates to consent clauses outside of that usual landlord and tenant scenario. And so it will hopefully be of interest to any commercial lawyers out there, or any non-property lawyers who aren't so used to dealing with giving consent under a contract. So to give you a little bit of background about what this case was about, it related to an agreement for the transportation and processing of hydrocarbons. Now, don't worry, I'm not going to get into detail about what that means. I have no idea. It's sufficient for our purposes to know that Apache, the claimant, produced hydrocarbons and transported them through Ineos's defendant's pipeline. So here, annexed to the agreement was an attachment which provided that if Apache wanted to amend its estimated production, which really means if it wanted to transport more hydrocarbons, then Ineos would not unreasonably withhold its consent to such an increase, provided, of course, that the pipeline had capacity to do so. Now, Ineos indicated that it would only consent to this if Apache agrees to revise the tariff it paid for the transportation and processing of the hydrocarbons. So the court was asked to determine whether Ineos was acting unreasonably or in breach of contract by withholding consent on this basis. Now here the court held that it was illegitimate and unreasonable for a party to withhold its consent in commercial contracts in order to obtain financial advantage from the other party that it was not otherwise entitled to under the contract. Now, one of the key considerations here was that the increased tariff that INEOS demanded was not compensatory in nature. So, for example, if it was a payment that one party wanted to compensate it for example, increased costs as a result of transportation, it might have been legitimate and reasonable, and the court might have agreed with that. This case was simply a result of INEOS wanting to make more money and line its own pockets. The court considered that the condition would have the effect of altering the parties' rights under the contract significantly. And that's a really key point in how it dealt and how it interpreted this particular agreement. So what's the take-home point from this case? Well, I should say it and stress that it is possible for parties to impose conditions on the granting of a consent under the commercial agreement. The problem comes when the parties try and increase their rights under the contract, for example, by demanding more money as a condition of the consent being granted. Now, if the money is genuinely to compensate one party, it may be acceptable, but you are advised to be cautious about being greedy and imposing conditions in order to line the pockets of the company. That's where the court are going to take quite a strict view. So moving on to another examination of perhaps very commonly known phrase, and I'm sure it's something again which even if you don't deal with in your day-to-day work, you probably remember from your law school days or from reading your contract law books. It's the phrase good faith. What does it mean when parties are obliged under commercial contracts to act in good faith towards one another? What does it mean? Now, this is a term which keeps popping up, and you may be familiar with if you have attended our previous contract law updates in which we considered it quite a bit. But it's something which the courts and parties clearly grapple with, and it's something again which the court has considered last year, Essex County Council and UBB Waste. Now, I probably should have ended with a more glamorous case than the present one that we're about to discuss, but I'll leave it for your own judgment. Just to give you a bit of background again about what this case was about, Essex Council entered into a contract for the construction, operation and maintenance of a plant to treat household waste in Essex. Now, I did warn you that it wasn't the most glamorous case to end our session on, and I should have found a better one. But again, the legal principles, at least, I think are quite interesting. The facility was constructed and was required to pass acceptance tests that would demonstrate that the facility could meet the performance requirements set out in the contract. However, it soon became clear after the construction and running that the facility was seriously underperforming. Now, UBB, the party who constructed it, proposed making various changes to the facility to make it easier to pass the acceptance test. However, they failed to pass the acceptance test by the required date. Now here, Essex Council argued that this failure meant that UBB was in default of the contract and it was entitled to terminate in accordance with the termination clause. Now, UBB denied this and rather amusingly alleged that the problem lay with the composition of the waste that it received. And it kind of reminds me of that, that well-known argument used by train companies about the wrong type of snow or wrong type of leaves on the track in the autumnal and winter months. But there we go. I don't want to know why the waste was composition of the waste was incorrect. We probably won't delve into the finer detail of that argument, but essentially they argued it was the wrong type of waste. It also sought to argue that the contract was a relational contract, and these are typically long-term agreements involving substantial mutual commitment, extensive cooperation and communication between the parties, and therefore that the duty of good faith was an implied term given the nature of the contract. Now, UBB alleged that the council was in breach of this duty for a number of reasons, including a failure to agree the changes to both the contract itself and the acceptance test, which would have enabled the facility to pass the commissioning period. So it's quite a bold argument when you're alleging that the other party are not working in good faith because they're not working with you to make passing of the acceptance test easier to do. Now, perhaps unsurprisingly, the court found in favour of the council and rejected UBB's arguments. It held that UBB was in continuing breach of the contract and that the council was entitled to terminate the contract for default. On the key question of good faith, the court rejected the argument that the council had breached its duty of good faith. It confirmed that whether a party had acted in good faith was an objective test, and it depended on the contract and all the circumstances. It was not a necessary ingredient for a party to be dishonest in order to find that there's a breach. The question is whether the conduct will be regarded as commercially unacceptable by a reasonable and honest person. So what are the practical points to take home here? And I hope you don't come across contracts involving the disposal of human waste, but if you do, and if you're faced with such an argument as, say, a contract passing an acceptance test, the judgment here really emphasises the importance of agreeing with the scope of the contract, and the testing is right at the outset. If the contract's impossible to perform, the customer will not necessarily be obliged to agree any proposed changes. The duty of good faith will not stretch to allow parties to avoid their rights under the contract. And so it's such a kind of is, I think, important decision, one which has a lot of practical relevance, because of course you can seek to agree changes to the commercial contract during its lifetime if your contract provides for that, and if the parties are amenable to that. And it's something which, if you come across a problem in a contract or something which isn't working, obviously parties have every right to see whether they can have a discussion with the other party to agree changes to it. I think the point here is when you're agreeing changes for your own benefit, and when it's something as fundamental as the performance of a plant or the performance of mechanics or here a waste disposal plant, if you're doing it to make your job easier and to make you assured to pass any contractual obligations and the other party doesn't agree, it's going to be a stretch if you want to say that that party isn't acting in good faith. And again, as this contract and as this judgment highlights, it's all to do with the drafting of the contract. So this isn't necessarily an example of courts having a very, very unsympathetic approach, and it could well be that acting in good faith is found given the circumstances of the contract and if it provides for it. Here you're going to have a difficulty if you want to pursue a good faith argument, but it's something very subjective, and you're alleging another party isn't playing ball with you. So it's something to bear in mind going forward. So that brings us to the end of our contract update. Again, the aim of this wasn't to give you a law lecture or to make you revisit your dusty law books or your contract law sessions from when you were a student. It's really looking at things which we think are interesting, decisions of the court which have been handed down recently, which may have some practical relevance to you. Whether you're pursuing those types of arguments or whether you're coming across contracts which raise those types of arguments and issues, or whether you're defending them. And I think a really practical one, a good example here was that case where the tenant was alleging that COVID-19 rendered it really difficult for them to make payments of rent and service charges. And I can imagine many situations where you may be pursuing those types of arguments or you may be defending them, and it's something just to kind of flag and to have in your consciousness if you're dealing with them. Maybe you can raise the argument or raise a case in your correspondence with the other side, and hopefully it will be of some assistance. But that brings us to the end. I hope you found it helpful. If there are any questions, please do let me know and I will do my best to answer them. But thank you very much for your continued attention, especially on a lovely Tuesday morning. And I hope you found it interesting. Thank you very much.
Thanks, Sarah. And I found that interesting. So I hope everyone else did too. So I just wanted to start by reassuring anybody who perhaps wasn't in the beginning of the session. The recording for today will be circulated, and we will also be circulating the slides. So not to worry if you think there are any points you might have missed, or if you dialed in late, or anyone that has had to dial off early, that's no problem, and that will be coming round. Sarah, force majeure versus frustration has been a hot topic in the Q&As, particularly around the Salem case. So kind of the theme of the question seems to be, what about force majeure in this alarm case. Why, you know, if frustration wasn't going to be allowed, why wouldn't they have been able to rely on force majeure? And also whether it's better to rely on force majeure rather than frustration. I mean, my understanding has always been that it's better to go with force majeure because that's the negotiated position.
It is, absolutely, and it's something, and again, it is kind of one of those points which the court emphasised on cases such as this. It always comes down to the particular wording of contracts entered into and negotiated between the parties. Here, I would have to have a look. I understand that, again, with contracts that we come across on a day-to-day basis, it's not necessarily a standard term. So force majeure clauses can absolutely appear in contracts, and some that we have seen do specifically mention in pandemics. So if you came across a force majeure clause in a commercial contract which had that, then brilliant. It's always better to rely on breaches of contract which are explicit and express, rather than relying on the common law doctrine of frustration, which can be more difficult. And I think it's especially more difficult to pursue arguments on under force majeure clauses, basically because the courts will, as we have seen throughout these cases, are very eager to hold parties to what they've negotiated and what they've bargained and to the particular terms of a contract. And if you're looking at frustration, say for example, if you haven't got this particular terms in an agreement and you haven't got, maybe you do have a force majeure clause, but it doesn't mention pandemics or illness or anything like that, and you want to rely on frustration, as we've seen, it's going to be a difficult argument to do, and particularly on a case that we're working at on the moment. Advice from counsel and from us has very much been, we don't know how the court is going to interpret the doctrine of frustration going forward. So it is a more risky argument, just because we're going to expect really a deluge of cases hitting the court in coming months and years. And the court, no doubt, are going to change their approach, and they may make it even more difficult to pursue frustration arguments going forward. And so if you're a party looking to rely on frustration, it's going to be a risk. And we always talk about litigation risk in pursuing these arguments, but I think it's going to be even more relevant going forward, because we simply don't know what the position is going to be. And the court can take an even stricter approach. And here we've seen the Salem case, and you think it's going to be a typical case of frustration, and the court didn't agree. Here, if they could have relied on an explicit contractual provision, maybe the outcome would have been different. But given that they didn't, and given that they pursued the frustration clause, the doctrine of frustration argument, it led to an unfavourable outcome, because again, the court wanted to uphold those explicit contractual obligations. So yeah, really, really challenging. If you do have a clause, I think the main point is rely on that rather than frustration.
Yeah, and I think that answers most of the questions on that topic. And just a related question then, I think you've answered as well. How often do you see the courts upholding the argument that an agreement has been frustrated? I think that's rare, isn't it?
Really rare. Again, I think these cases really emphasize the fact that the court will look at, there's going to be so much evidence about how COVID-19 has devastated parties, whether you're tenants, whether you're airlines, and the devastating consequences of not being able to fulfill your business, not being able to book flights and travel, and not being able to open commercial premises and make profits, and meeting all your obligations under a contract, such as the most basic requirement of paying rent. And the courts see that, and there's so much evidence that parties can produce to the court, given, highlighting the devastating impact it's had on them. And it's something which, as we've seen, at the moment anyway, the court has very little sympathy with. If the parties have negotiated that they're going to continue meeting their obligations, no matter what happens. So again, it comes back to what's in your contract. It's really important to have a look at it. For example, on the rent case, if the parties have negotiated that these obligations are unconditional and they are not dependent upon any way upon the ability of the parties to, say, open a shop or run the airline, you're going to have a really difficult time convincing a court that the contract's been frustrated. And again, I think one of the take-home points here is the conduct of the parties in these various scenarios. So if the parties raise frustration arguments later down the line, but the court looks back at exactly what their conduct was at the time of this event took place, whether they are trying to run the business and continue making a profit or continue trying to run the airline and not treating contracts as frustrated, that's always going to be really relevant too. So yeah, it's going to be an uphill battle, but again, it all depends on your contract and what you've agreed with the other party.
Thank you, and I hope that helps with the questions that were being asked around that. A kind of related question again, has force majeure been accepted in COVID-19 cases? I think we're still kind of waiting and seeing, aren't we?
It's very much, yeah, absolutely, Jo, like very, very much the case. And this is kind of one of the frustrating things at the moment, that obviously it's such a topical issue. And we simply don't have the case law at the moment. And no doubt cases on those issues will be either process of being issued, process of being run before the courts, but we simply haven't got the judgments yet. And it's not surprising, given that this is a relatively new phenomenon. In that cases we've looked at have been the first reported which have considered these issues. And no doubt there will be many, many more cases to come this year and next year and going forward. But this is the thing, it's so difficult to give any guidance on COVID-19 related issues and commercial contracts because we simply haven't got the case law yet. And judges are probably having a good think about how to interpret them. And it could lead to a change, and we simply don't know what that's going to be. And I think it comes back to the point I mentioned earlier, that it's a lot of risk around these arguments because it's not like you have a bundle of case law and a bundle of recent decisions by the court which should consider these issues. We simply haven't got it. We're beginning to get a trickle through at the moment. Hopefully in the coming months and years, the position will be clarified. But who knows? So it's a big question mark at the moment, and it's very much a kind of watch this space topic.
Yeah, and I think that's a frustrating answer, don't we, Sarah? But we just don't know.
Very frustrating.
If the judges don't know, we don't know. But as you say, hopefully things will start to trickle through, so have a bit more guidance. Okay. What would be the best practice to confirm to the other side that may not know what subject to contract means that discussions are indeed subject to contract?
Interesting question. And I think when we talk about subject to contract, it's usually in the context of parties being represented by solicitors who obviously know the implications of that. So the case we looked at before, the Joanna and Money Thing case, both parties are represented by solicitors, and obviously for a lawyer, it's fairly commonplace to use it. So I suppose your question really relates to whether parties are unrepresented or whether you have one party who's represented and another who's not. And I think if that's the case, there's never any harm in heading your first communication subject to contract and in the opening line of your email saying this email is sent to you on a subject to contract basis. Which means that the discussions which take place forthwith are not intended to have any legal binding effect. And obviously a party may come back and ask further questions, but I think if you stated at the outset and made it clear, and it's a fairly clear thing, we're not talking about kind of really complex legal arguments and legal terms here. It just means that if you are entering into those discussions, you're not entering into a fully binding agreement. So I think if you make it clear in the opening email and proceed thereon, and it's for the other party to come back if they are unrepresented and ask questions about that. I think one of the things that I always tell lay clients in that situation is, and even represented clients, you're not the lawyer for the party. So if the other party wants to get legal advice on that, you can maybe add a sentence to say, if any of this is unclear, we recommend that you seek independent legal advice. But it's not for you to give them advice. I would just make it clear that's your interpretation and that's your intention entering into those agreements on a subject to contract basis.
Yeah, I would agree with that. It's certainly not your job to start giving the other side advice. And another subject to contract question, actually, in the absence of the word subject to contract, would the outcome of the Joanne case be different, do you think?
really interesting, because here this case was all about, I mean, the parties were really liberal in their use of subject to contract and same with that prejudice subject to contract headings. I think definitely there could be, and for example, from a personal perspective, when you're negotiating, say, a settlement of a dispute with the other party, not all your communications with the other party will necessarily be headed subject to contract. They may be headed just without prejudice, they may have no headings whatsoever. And I think the court will look at the substance of what you're saying with the other party. And so if you have an email, for example, with the other party saying, right, we're formally agreeing terms, here they are, ABC, and you're using words to indicate that you intend to be legally bound by those words, you're going to have a hard time wriggling out of that. But the other probably more typical, more common scenario is where you're negotiating terms with the other parties. So for example, you're making offers of payment, you're negotiating the mechanics of it. It could be a lot of proposals being put forward by the different parties, how payment, for example, could take place practically. And I think one of the key things highlighted in the Joanne case is whether the parties have signed an agreement. And here it could be a formal agreement, it could be an email just with the words, we agree that, ABC, it could be entering into a consent order. If you haven't done that, and all you've got are kind of a body of emails in which you can be making discussions and proposals and counter proposals, I think the court will look at that and assess all the facts and assess all the circumstances. And if there isn't a contract, and there's no written communication or no kind of telephone note saying, aha, today we entered into a contract with the other party, the court will take it for what it is. And so even if you haven't got every email with the subject line, subject to contract, you're going to have an argument that, well, clearly no contract and no agreement has been reached here. So I think for clarity, it would be better to limit any potential arguments in the future that you had somehow reached a binding agreement, for you to use words which makes it really clear. And again, subject to contract is such a short, easy phrase to put in as I mentioned earlier, in the email subject line. It doesn't have to be a kind of really formal kind of, really kind of bold term, as long as it's used somewhere. I think you've got a good argument that you're not getting yourself into some kind of legally binding situation.
Okay, yeah, thank you for that, Sarah. Got a good faith question just to mix it up. So in relation to the duty of good faith case referred to, could you raise similar arguments where the contract requires parties to act reasonably, where, say, a supplier is seeking to move a delivery date?
Absolutely, and this case was specifically considering, or the court specifically considered good faith, but there has been case law where they've considered what does a party acting reasonably mean and how far do they have to go. And here a court will always look objectively. So they're going to say, what would the reasonable commercial party be required to do here? And it's really about whether one party's conduct, or whether one party, in asking the question about acting reasonably or seeking to dispute that one party has indeed acted reasonably, whether that's reasonable and whether that in an objective sense would be held to be reasonable by the court. And I think here, if you're looking at a particular situation where you're arguing that one party hasn't been reasonable simply because they're not doing what you want, and particularly looking at the wording again of the agreement, it all comes back to what the parties have agreed. So if you're looking at a particular case where, well, actually under the contract, they're not entitled to do that and they have no obligation to act reasonably, it's going to be potentially difficult to argue that in that particular case, just because they're not playing ball with you, they've acted unreasonably. So I think the take-home point is it's not a subjective test, it's an objective one. But I think the point here too is that I wouldn't forget the importance of potentially employing these arguments in negotiations with the party. So here, like this morning, we've been considering how the court has interpreted them, and that's obviously gone right through to contract pre-issue discussions, right through the litigation process to the court. And I think it's really important, if you're seeking to rely on these types of arguments or seeking to defend them, don't forget that in your pre-contract or pre-litigation discussions, they may be useful bargaining chips, and they may be useful for negotiation purposes. So even if you think legally, looking at this case law, and maybe a court would hold that they have acted reasonably or unreasonably, it's always useful, I think, and given that you have a fairly coherent argument, of putting that into your letters or into your correspondence, or picking up the telephone and saying, I think there's an argument here that you haven't acted reasonably, and exploring that. And I think from a kind of strategic and putting a pressure and applying pressure on the other party to get what you want and to reach an agreement or settlement, it's always worth bearing in mind that, yes, maybe the court haven't given you the answer that that you're looking for in terms of its reported judgment, but it may be worth having a discussion with the other side about it and raising it as an argument, and seeing where you get to. And certainly from our perspective, there's always a fine balance between pursuing arguments which are completely hopeless, but ones which may have actually a shot at winning, and employ that in your discussions with the other side. You never know where you get to. You could end up getting what you want. So have a shot, but I think the time to take a more serious look at these arguments is whether you're preparing to issue a claim at court.
Give it a go.
Give it a go.
Okay, we're back to subject to contract, and another thing that litigators love, which is without prejudice. What is the difference between using without prejudice and subject to contract in communications, as applied to the case you mentioned?
That is very good, and you're testing my knowledge. So in this case, as we mentioned, some of the discussions, some of the email discussions were headed just subject to contract, and some of them were headed without prejudice and subject to contract. Now, as a litigator, without prejudice, you employ that phrase either without prejudice or without prejudice save as to cost. If you are genuinely trying to reach a settlement with the other party, and that can be before you've issued a claim, during the litigation process. It's a genuine attempt to settle a dispute. And what it means is it really has cost consequences. So if you get all the way to trial and you're successful and you say, aha, judge, I have tried to settle this dispute, and the other party kept rejecting it, or they weren't engaging in the settlement discussions, I should be awarded costs because of their unreasonable behaviour. You can potentially put settlement discussions before the court on the issue of costs, and in the hope that the court will pay you money because the other side should have settled and they didn't. Second to that is if you had settlement discussions without prejudice, in which case they can't go before the court whatsoever. And so it's a way that the parties can conduct settlement discussions basically in privacy, and the court are never informed of it. If they're headed without prejudice save as to costs, it means that the court can't be informed of it on issues of liability. So, for example, who's right and who's wrong. But if you get to judgment and you win, and the court are looking at costs, then you can say, then basically you can give the judge all your without prejudice subject to cost emails. And the court may say, well, party A, you've won, you tried to settle it. I can see from all the settlement offers that you made some really good offers. The other party should have accepted them. And if they did, we wouldn't be here today, and penalise the other party for not engaging sufficiently in settlement discussions with you. So really, that's kind of a long way of saying without prejudice is very relevant if you're in litigation. And it's whether you want the court to know of your settlement discussions or whether you don't. And there's no obligation to head settlement discussions without prejudice. We have some where everything is made on an open basis, so not without prejudice, and everything open can be placed before the court, show exactly what the parties have been trying to do and trying to settle. So yeah, very relevant litigation, very relevant for cost considerations. Subject contract again is different because you're not looking at necessarily litigation. So I know a lot of commercial and property lawyers out there will use subject to contract, having no regard really for or anticipation that any matter will go to litigation, but purely to ensure that you're not reaching a binding agreement. So it's really very different considerations. I'd say probably litigators would probably potentially use a combination of without prejudice and subject to contract again if they were negotiating something like a settlement agreement of dispute. But for commercial and property lawyers out there, if it's not disputed and it's just a kind of regular commercial negotiation, you may not even use without prejudice. Really dependent on the circumstances and whether you think a claim may head towards litigation and maybe disputed by parties.
Thanks, Sarah. If something's marked WP, it attracts what we call WP privilege. And if you are interested to find out a bit more about privilege, we did a session on that last time around, so in the autumn, and that can be found on the on-demand section, on-demand webinar section on our website, if that is of interest. Okay, we are bang on 11:30, so I'm going to wrap it up there. I am conscious that there are a few questions we haven't got to, and we will try to follow up. We will follow up on those afterwards. So thank you very much for attending. Thank you to everyone who bore with us through the crucial question and answers, as well as Sarah's presentation. And I hope you all have a lovely day.